9, Paul Quinn.
Thank you, Mr. Speaker. My question is to the Minister for Treaty of Waitangi negotiations. What recent progress has the government made towards its goal of settling historical Treaty of Waitangi claims by 2014?
The Honourable Chris Finlayson.
Last Sunday, the Crown signed terms of negotiation with Ngāti Koro ki Kahukura and Ngāti Hoa at Pohara Marae. Between the start of last year and June this year, the Crown has reached over 30 significant settlement milestones, including 14 agreements in principle and 6 deeds of settlement. This represents great progress, especially compared to the previous administration's average of 1.6 deeds of settlement each year.
Paul Quinn.
Mr. Speaker, thank you. What support did Budget 2010 provide to help achieve the government's goal of settling historical Treaty of Waitangi claims by 2014?
The Honourable Chris Finlayson.
Mr. Speaker, this year's budget provided an extra $6.5 million over the next 3 years to help achieve the government's goal of settling historical treaty claims by 2014. This extra funding comes on top of the additional $22.2 million in last year's budget and illustrates the government's commitment to accelerating treaty settlements.
David Garrett.
To the Minister of Treaty Negotiations, will the settling of claims to customary title over parts of the foreshore and seabed under the government's proposed legislation impact in any way, shape or form on treaty claims, and if so, in what precise way?
The Honourable Chris Finlayson.
Well, that question raises a number of points. First, I've made it clear on a number of occasions that if an iwi has concluded a treaty settlement, it will be able to come and talk to the Crown, for example, about extant customary rights it may claim, but that the finality of its treaty settlement will not be able to be challenged.
David Garrett.
Will he be advising the Attorney-General that the foreshore and seabed legislation should specifically prohibit any holder of customary title from charging those who wish to enjoy customary recreations, such as fishing and swimming, for access to areas of the foreshore and seabed held under customary title? If not, why not?
The Honourable Chris Finlayson.
Well, the Attorney-General and the Minister in charge of treaty negotiations exchange pleasantries all the time, and I imagine that the issue of when another day, another psychotic outburst from Mr. Mallard.
Order.
Point of order, Mr. Speaker.
Just before I call the honourable member, it's going to lead to disorder if members use an open microphone to make unhelpful comments across the House. I do recognise it was done in response to a fairly unhelpful interjection, but these things will tend to lead to disorder. David Garrett, point of order.
Point of order, Mr. Speaker. My question was carefully worded and asked the Attorney-General if he would the Minister, if he would be advising the Attorney-General with regard to the content of legislation. The answer I got was related to social intercourse between himself and that minister, with absolutely nothing to do with the question.
Order. I accept the point the member's making, and that I believe the minister in answering was probably a bit sidetracked by the interjection, and I think it was a serious question the member was asking, and I'd ask the minister if he could answer beyond just whether he talks to himself or not.
Yes, of course. Yes, there will be discussion between the Office of Treaty Settlement and the Ministry of Justice. I can assure the member what I said yesterday was right, that there is no question of access to the foreshore and seabed. He need not have any worry about that issue.
Question number 10, Lynn Pillay.
Thank you very much, Mr. Speaker. My question